Welcome, everybody. I think we'll get started now. Thank you so much for joining us here today. We are so lucky to have here at Duke Law School this panel, particularly here on the celebration of the 11th anniversary of Data Privacy Day. And we'll talk a lot more about what that means. I want to personally thank the panelists for agreeing to come and to be part of this. I also want to introduce myself. I'm David Hoffman. I am a senior lecturing fellow here at the law school, teaching information privacy and surveillance law with Professor Schrader. In addition to that, I'm Associate General Counsel and Global Privacy Officer at Intel Corporation. Intel Corporation is sponsoring this event along with the Law Ethics and National Security Center. Thank you, Professor Dunlap, and the Center for Law and Technology. Thank you, Professor Ward. And so we're really excited to bring together the different portions of the privacy conversation that make up those, whether it's technology, whether it's ethics and national security, or whether it is really focused on the legal dynamics of technology. We're going to talk about that all here today. So let me introduce the speakers briefly, and then they can describe a little bit more of their backgrounds and their roles. Professor Jolynn Dellinger, who's teaching the privacy class here at the law school, a long history in privacy going back to being the founding coordinator of Data Privacy Day and organizing privacy events and privacy scholarship all over the world for over a decade now. Leonardo Cervera Navas, the director of the European Data Protection Supervisor's Office, joining us from Brussels, but also a former senior fellow here at Duke for a year, which we'll describe that a little bit more, and leading data protection official in the European Union for close to 2 decades. Dan Caprio, co-founder of the Providence Group, former Chief Privacy Officer at the Department of Commerce, and former Chief of Staff for Commissioner Orson Swindle at the Federal Trade Commission. So with that amount of decades of experience here, I think we're going to have a lot to draw upon to weave together how privacy has been changing over time and where we are as we look at Data Privacy Day in 2019 and what we need to do moving forward. So to kick us off, I wanted to ask Professor Dellinger maybe to go back a bit and say, where did Data Privacy Day come from? Where were we at then? And where has it evolved?
Sounds good. We were apparently at a dinner table. We were comparing our memories from Data Privacy Day last night. And as David was reminding me, we were at a dinner table with Leo, who was in town, and Francesca Bignami, who is a professor here at the time. And the quick version is that Leo brought to us an understanding of an enthusiasm for Data Protection Day, which was first celebrated in the EU in 2007. And David had the vision as Global Privacy Officer for Intel to imagine what a Data Privacy Day could look like in the United States. And I had the time to coordinate our national and somewhat international programming over the next several years. And so it was just a bringing together of these ideas, and it's truly terrific to be here at the 11th Data Privacy Day, and it's still a thing, which is nice when you work hard on something for a while. But before I go into more of the history of Data Privacy Day, I wanted to give you a sense of where we were. I think it's always important to have context. With technology, I think it moves so quickly, but on the other hand, we so quickly become used to the technology that we can't imagine being without it. And clearly I'm not without it. Here I am on a panel with my phone. So I just want to give you a reminder of what 2007 was like before I go into the history. So in 2007, Facebook had just become available to anyone with email, starting in September of 2006, I believe. By July of 2007, Facebook had 30 million users. Now, today, over 1.5 billion people log on to Facebook every day. The iPhone had just come out in 2007. That was the first year of the iPhone. As of October 2017, 78% of teenagers own a smartphone. As of February 2018, more than 77% of adults own smartphones, and 95% of all adults own phones. 1/3 of American households have 3 or more smartphones today. So when Data Privacy Day started, I was using a flip phone, as I'm sure David was. So to focus in on that for a minute, that meant, and my flip phone honestly was rarely on, which my husband said kind of defeated the purpose of being able to get in touch with me by cell phone. But imagine that time when hours could go by and no one knew where you were. Or they couldn't even get in touch with you because your phone was off, right? So I just want you to have that in your mind of how much things have changed since 2007 when Data Privacy Day started and people were becoming very concerned about these issues. So with our flip phones and our newbie status on Facebook and our portable computers that felt like they weighed 15 pounds and maybe in fact did weigh 15 pounds, we launched into this organization of Data Privacy Day. So the date is January 28th. That's the date that we celebrate Data Privacy Day on. It's because that's when Data Protection Day is celebrated, and that is because that is when the Convention 108 was open for signing. January 28th, 1981, this is the Convention for the Protection of Individuals with regard to automatic processing of personal data. And it was the first legally binding international instrument in the data protection field. And it required parties to that agreement to take steps to ensure support for the principles of fundamental human rights of all individuals with respect to the processing of personal data. So that's why that date was chosen, January 28th. I'm just telling you because people often said, why are you planning this in the middle of the winter? Ice makes it hard to get places. So we had to deal with that, but that's when it is, and it matters when it is, so we stuck with that. The first Data Privacy Day event was here at Duke Law School. This means a lot to us. David and I both graduated from Duke Law School in '93. Leo was the EU fellow here at Duke Law School, and the law school provided support for that initial Data Privacy Day event. It was focused on transatlantic cooperation around privacy issues. Dan was one of our first calls and helping to get the FTC, Commerce involved, different people from government. Leo participated, as well as Ann Kleinfelter, whom some of you may know from UNC Law School. And with Leo's help, we were able to have, at that first Data Privacy Day celebration, Peter Hustings and Giovanni Butarelli. And for those of you who don't know, this is like the all-star cast that Leo was able to bring to us, to Duke Law School, for that first Data Protection Day. Peter Hustings was then the European Data Protection Supervisor. He served in that position from 2004 to 2014. And we had Giovanni Butarelli, who was at that time the Secretary General at the Italian Data Protection Authority and is now the European Data Protection Supervisor. So as I said, all-star cast here at Duke Law School for that first Data Protection Day. And over the first 5 years, we built Data Protection Day into an educational and awareness-raising international annual event. It was designed here in the United States to promote interaction among and involvement by a wide variety of stakeholders that have something to do with privacy. Academics, nonprofits, businesses, both large and small, government entities and representatives, and that's on the state, federal, and international level where possible, and to encourage a discussion of and understanding about a variety of privacy issues. And this was anything from health privacy to the emergence of smart grid, education privacy, what teens were doing on social media and how to protect themselves in that context, behavioral tracking, national security, employment privacy. As an example, in 2010, we did a reader privacy event at UNC. We also had a roundtable at the FTC that year about the role of commercial players in the digital economy. And Microsoft did a very interesting study that year as well on the way that human resources professionals were using social media information in the context of hiring decisions, which was new then. I know it's a given now, but it was a new idea back then. The following year, we actually held a national security roundtable with the help of David Shanzer and the Public Policy School here at Duke. The House and the Senate both recognized Data Privacy Day as a national day in 2009. And I know there are a lot of national days like National Corvette Day and National Future Dog Day. I don't know, there are a lot of them. But this was a very interesting process to go through, and to actually get the House on board was amazing. We had to talk to so many people. It was amazing, and it was part of the awareness-raising effort. The Senate then went on to recognize Data Privacy Day for several years. The National Association of Attorneys General also recognized Data Privacy Day, along with a host of states on the gubernatorial level. Also around the country, Data Privacy Day offered an opportunity for privacy professionals to get together in their communities and share resources and meet people. And that effort, once again, was led here in North Carolina taking the lead, by Judy Beach, who is here today and who has been at every Data Privacy Day since January of 2008, supporting with events with the Carolina Privacy Officials Network, which she founded, and helping bring people together around privacy issues. So Data Privacy Day had its home at Intel for 2 years. It moved to the Privacy Projects for several years, 3, I believe, and then went to the place where it is now, the National Cybersecurity Alliance. David and I and Dan have all continued to be involved in Data Privacy Day through the board, and Dan extremely generously chaired the advisory board for Data Privacy Day for 8 years. So that's a little bit on the history of it, and then we look at how things have changed from 2007 until today with respect to Data Privacy Day. Well, one thing that has not changed is Duke Law School's support of the exploration of privacy issues. So we started out here with a 2-day conference at the nascent Data Privacy Day, and this year Duke Law School is offering no less than 5 classes in the area of privacy and security, which is great. But other things have changed, and I think the increased attention to privacy academically is more than merited by the societal and technological changes that we've experienced in this 10 or 11 years. The ubiquitous presence of the smartphone that we mentioned earlier, the emergence of big data analytics, combined with the relatively unrestrained data aggregation practices of private companies, the substantial level of government surveillance revealed in part by the Snowden disclosures, cooperation between corporations and government on matters pertaining to data collection and use, the incredible low cost of storage, the existence of the cloud, and a whole host of new surveillance technologies, including GPS, cell site location information, stingrays, license plate readers, CCTV, drones, biometrics, including facial recognition. So people can undoubtedly feel overwhelmed by all of these changes and all of these technologies and think protecting their privacy is just an impossible task. But actually, that whole privacy is dead argument has made a pretty regular, surfaced kind of regularly since the 1850s. Someone's always got that to say. Likewise, however, in the United States, the impetus for and the drive towards privacy regulation of one kind or another has often occurred fairly regularly. So that's usually in reaction to significant cultural events. Emerging technologies and recent cultural events seem to have brought us to a moment now in which many people are once again beginning to call for a more comprehensive legislative approach to privacy. The idea seems to be taken seriously by a wide range of parties. Whether we can overcome political polarization and divisiveness to accomplish anything in this area remains to be seen, but I will throw out there that in my experience, there are a number of areas of privacy that are very bipartisan. And this could be an opportunity to actually get people together from different sides of the aisle. Not always, and it won't be easy, but it's a possibility. So with the advent of the GDPR, many US companies are finding themselves in a position where they have to comply with more stringent privacy rules. The real threat of fines and penalties, I think we will see the French Data Protection Authority fine Google $57 million for not properly disclosing to users how data is collected across its services. And that was just earlier this week. But aside from that, it also seems that people are taking more of a time to talk about broader principles right now. A renewed call for a data bill of rights that includes things like being secure against unreasonable surveillance, or the right not to have your behavior surreptitiously manipulated, or the prohibition of unfair discrimination based on data. And so along with that, I think we can certainly say, at the very least, that people are really talking about the efficacy of the notice and choice framework for privacy protection that exists today, and whether control over our information is really something that even remains possible, or whether that should be our sole goal. So Data Privacy Day, as we envisioned it back in 2007, was all about promoting cross-cultural conversations and communications across different fields of interests. That conversation, in my mind, is more valuable than ever today. So I continue to hope that our collaboration with the EU, the fact that we can get Leo to come all the way to Duke and sit at the same table with us around these issues of privacy, I hope that that leads us not just to a consideration or an approach that's economically feasible for American companies. I definitely want to get there. We need to have compliance. But I'm also hoping that it takes us to a place where we have more time and more willingness, as we learn, to consider the ethical uses of big data and emerging technologies from the privacy perspective. So my view is that Data Privacy Day is still tremendously relevant, and that it will be a catalyst for that conversation in the years to come. That's what I hope to see, and I couldn't be more thrilled that you guys all took your time to be here today and be part of this Data Privacy Day celebration.
Thanks, Jolynn. So Leo, Jolynn really has noted this evolution of what we've seen along the various data privacy days that we have done. There's been a tremendous evolution that's also gone on in the European Union, and I would say even an acceleration of that in the last couple of years. Could you catch us up a little bit on what's been happening in the European Union?
With pleasure. Thank you very much, Professor Hoffman, and the organizers of Data Privacy Day here for keeping the celebration and for making it possible to have an exceptional dialogue between Europe and the United States on this issue of privacy. I would like to briefly mention three things. One is, why is data privacy so important today? What is going on in Europe and in other parts of the world? And how do I see the evolution of data privacy here in the United States from a professional and personal viewpoint? So why data privacy? Data privacy is something that is very old. Data privacy is something that is very new. Privacy is something that is in our legal system for more than 200 years. Actually, it's something that started with the French Revolution or with his precursor, the American Revolution. It's the idea that everybody has the right to be protected in their own home, their communications, in their intimacy. But this privacy right is a condition sine qua non for the exercise of other rights. And this is something that the jurisprudence here at the US has developed enormously. And I remember when I was sitting in the US privacy classes here at Duke, because most of the time I was sitting and learning US law, and I was with Professor Reitman, for example, learning about US copyright law. So I was amazed how the jurisprudence of the US was focused precisely on this, on the fact that privacy is a condition sine qua non for the exercise of other rights, such as the freedom to express information and to receive information anonymously, something that is really now under threat on the internet. Can we really express ourselves or receive information anonymously? Or the freedom of assembly without being tracked, or the freedom to vote without being surveyed? Or privacy becomes a precondition for the exercise of these rights. But at the same time, data privacy has become a second generation right, which comes from this old privacy right, but now has become a different right on its own, because the level of surveillance and processing of personal data that we experience today is so massive, as Jolynn very well explained, and so deeply intrusive in our personalities, in our lives, that now this right is taking a lot of protagonism in the area of fundamental rights or constitutional rights around the world. So what is going on in Europe? In Europe, we started with data protection 25 years ago when we adopted a directive. And recently, 10 years ago, there were many voices saying that our legislation was outdated, that it was adopted before internet and we needed to change it. And our political class, European political class, got together and they started to update this right. And many thought that this would be bad for data protection. Many thought that they will weaken the protection. But amazingly, it happened exactly the opposite. The outcome of this political discussion was that this right was strengthened and was even given the category of a constitutional right, what we call in Europe a fundamental right. And you need to understand that the European Union is not like United States of Europe. It's very different. In Europe, we are not united on the idea of a flag or on the idea of even a single currency, because we have the euro, but there are some member states that they don't have the euro with them. Or we are not united on the basis of the same language, because we speak different languages. So what makes our union a reality is the adherence to a series of fundamental principles and values that we consider our true identity. And these values are basically the strong belief that peace should always prevail. So for us Europeans, wars are inconceivable nowadays. The strong belief that democracy should be preserved, the rule of law, and fundamental rights. Why? Because in Europe, we come from a history of wars and atrocities, and all of us, from Spain to Estonia, from Italy to Ireland, we all believe that the best way to make a future better for all of us is to be very strict with the defense of human rights. So for us, there is an Article 1 in our Charter of Fundamental Rights, let's say our Constitution, that says that human dignity is inviolable, must be respected and protected all the time. It's the only absolute right we have in the European Union, the human dignity. And how do you ensure human dignity in technological life? How do you ensure that the dignity of individuals is preserved online? The way we ensure that is by this data protection right. Because the data protection right is a right that is proactive. It tells governments and companies the behaviors that are tolerated and the behaviors that are not tolerated. And it's a right that is very pragmatic because it gives safeguards for the technology to thrive without invading or trespassing some red lines. So we like to say that in Europe, we like to see data protection like the rules of the road. So it doesn't mean that information cannot flow. Of course, information needs to flow. Of course, there must be exchanges of personal data. But what we say is that those cars moving around in the information society need to stop in the red lights, and they need to adapt to the rules. Otherwise, people get hurt. And this is the meaning of data protection in the European Union. And this is what has been now taken to the level of the constitutional protection in the European Union. And that's why when there is an issue with data protection, for example, the Google case, our court, European Court, says clearly and loudly that economic interests cannot be put at the same level than the right to data protection, because this is not the issue. This is, so maybe something is costly for a company, but this doesn't change the fact that a constitutional right is a constitutional right. And for us, data protection is a constitutional right. So this model is now 25 years old and is spreading around the world. There is now more than 100 countries in the world with data protection legislation, comprehensive data protection legislation. And most of the American countries have now data protection legislation. Brazil just signed up to legislation which is very similar to the GDPR. And this is something that is happening. And there is a generous consensus that technology cannot go on its own. Technology has to be always accompanied by a feeling that human dignity and the privacy of individuals should be defended and protected at all costs. So that takes me to the last part, which is how do I see the evolution of data protection here at the United States. 3 months ago, we had an international conference organized in Brussels, and our keynote speaker was Tim Cook. And he came and he said very clearly in front of all of the audience of 1,400 experts who came from all over the world, David was there, that it was about time that the US joined this club of countries with comprehensive data protection legislation. And I believe this week, the CEO of Microsoft more or less said the same. There is now a general understanding that something needs to be done. And at the same time, there is some worries here at the United States that the model that the US may put on the table may not be found good enough for the Europeans. And I would say that this is not the right perception, because we had more or less the same issue inside the European Union when we were negotiating our GDPR. We had different cultures, different perspectives. We had some countries in the north that were, like the UK, for example, that they are always very pragmatic, very business-oriented, and they didn't want to have a very strong legislation. And then we had countries in the south that are, for historical reasons, want to have very strong data protection and very strong enforcement. And we managed to find a compromise, which is the GDPR. So I cannot see why we cannot find a compromise between the European and the American approach. Both are extremely valid. They have the weaknesses and strong things. So I would encourage the US to come to the party with their own approach. And then I'm pretty sure we will figure out a way to take the best out of both systems. Because I believe in the same way that in Europe, usually there is a huge misconception about data protection in the United States. Most Europeans think that there is no data protection in the United States. It's totally wrong. There is a lot of data protection in the United States. The problem is different from what we have, but it's a lot of data protection. There is also a lot of misconception here in the US for what we do in Europe about data protection. Many people think that data protection is bad for innovation or bad for technology and so on, but this is not the case. We believe that data protection is the companion for technology, not necessarily an adversary to it. So I will stop here, otherwise it will take too long, but I would like to reiterate my gratitude to the organizers of Data Privacy Day for keeping on with this for 11 years is amazing, guys. You are doing great here, and to Duke University for helping with this when I was here 11 years ago. And I look forward to your questions and some debate so I can take back some feedback also to my European colleagues. Thank you.
Leo, thank you so much. So Dan, coming to the party, coming to the global party, as Leo says, you and I have been doing planning for coming to the party since probably like 1999, when the FTC organized its Committee for Online Access and Security. And it doesn't feel like the conversation's gotten any easier than it was back when you and I were wrestling with that in 1999. Where are we at now?
Well, thanks, David, and thanks for including me in the Data Privacy Day celebration. It's nice to be back here at Duke with Jolynn and Leo. So I think where we are now, I mean, let's sort of pause to reflect. We'll kind of take that 20 years and sort of cut it in half. But I think when we started Data Privacy Day in 2008, I mean, it was really, it takes a decade really to build and mature a movement. And Data Privacy Day was really built for this moment. I don't think we knew it, or maybe David knew it, but maybe Leo knew it, maybe I didn't know it, but it's built for this moment. And the idea that we had back then was, that every day should be should be Privacy Day for consumers. So in the early days, everything was very corporate. It was what companies were doing: self-regulation, privacy policies, privacy officers, and just, important steps. And David was a leader in all of that. But it was just early days. So what we're doing now here, fast forward 10 years, it's more important than ever. And I think what's happened, and I've got three reasons to sort of a three-legged stool, but I think what's broadly happened is that consumers have just finally had enough. That we've all realized that we're more than just a collection of data points, and that's captured, as David mentioned, the imagination of Congress. And privacy really is a top-tier issue, I think, for the first time in 20 years. And part of the reason I say that is because there have been lots of good faith efforts over the years, but they would always kind of fade away. It would be, we would have had a privacy bill this year, but for, name the issue. But this year's different. And I think it's different for three main reasons in 2018. One was the California Consumer Privacy Act. So California happened, other states will follow, right? The California legislation takes effect on January 1, 2020, and we have any number of, and it's very strong legislation. It's similar in some ways to GDPR. In some ways, it's actually more difficult than GDPR. It was born out of a ballot initiative that then turned into legislative drafting and a bill that was literally written in a week and passed in California, signed unanimously, approved unanimously by the California House and Senate, and then the governor. So it's a very difficult bill to comply with. The second thing that happened, of course, was Facebook and Cambridge Analytica, and that captured everyone's imagination. And the third thing that happened was the implementation or the effective date of GDPR in May. But it's that California legislation is what really drove companies to the table in Washington in terms of the need for preemption. And so there's lots of discussion now in Washington, and David and Intel have contributed to it in specific legislative language. But there's much more discussion now about user control, about preemption, about data deletion, about the ability to opt out. the need for more transparency, and then one that's near and dear to my heart, which is increased authority for the FTC. So we've got, what's changing is the business community, and it's not just the tech sector. Everyone is under the understanding that, that we need a federal standard to preempt California. So that includes, the Chamber of Commerce, the Business Roundtable, civil society, the Center for Democracy and Technology, any number of bills, discussion in the Senate Commerce Committee. Bills have been introduced by Senator Rubio, Senator Schatz, and in some ways, it's still kind of a work in progress. I don't know that we're close to sort of the final outcome, but we've got the Federal Trade Commission is having hearings. They revived hearings from almost 25 years ago, but looking broadly at competition and consumer protection, including privacy. The Department of Commerce, NTIA, has set forth a broad set of principles of kind of what a privacy bill would look like, and that their approach is sort of the notion of privacy and prosperity. The end state is they're trying to get to a more risk-based approach to privacy. So everyone's got a slightly different perspective. And then the other is the National Institute of Standards and Technology, NIST, is working on operationalizing, sort of working off of their very successful cybersecurity framework to come up with something similar for privacy. So there's a lot of good things happening, but the one thing that's constant in DC in the legislative process is, principles are, when it comes down to actually passing a bill and getting something that's signed into law, that principles are easy and legislation is hard. So we're right at that crunch point where we're going to have to begin to kind of think more specifically, and David's contributed to this, but the legislative details, there's broad agreement that we need to do something, but it's the working out of the process and the sausage making that we're about to encounter that's going to be very, very difficult.
Thanks, Dan. And it strikes me also how much both sides of the Atlantic have learned from each other in the past 11 years, which I think has really helped inform our process here in the United States. I have a number of questions, but I want to make sure we've got time for questions from the audience, and particularly from students who are here. Does anyone have a question that they would like to start with?
I was wondering, I'm one of Professor Hoffman's and Professor Dellinger's students, so thank you all for coming. I was wondering, and we discussed this a little bit in one of our classes, there's a big business in selling data, basically, collecting and selling data, at least in the US, and I would imagine in Europe as well. And I wonder, and a lot of companies that were not necessarily in the data business are now in the data business, and that's where they see their future. And I wonder whether the business of data is compatible and can be successful with increased privacy regulation and compatible with the principle of control over one's own data and notice and choice.
So I am really, no, this is great because we got into this a little bit at dinner last night and put it on hold thinking we would talk about it more. So I want everybody to take on the whole question, but particularly this aspect of control in this environment and whether we think that the extent to which we can deliver that. Jolynn, do you want to start?
Okay, well, I think that the business of data brokering needs to be compatible with regulation, because I think regulation is absolutely what needs to happen. And I have endless faith in technology, and that technology can make the things that these companies need to do possible if they direct their efforts in that way. I do think that the way things are now, it's very difficult to feel like you have control over your information. And I think most of us don't know, even if we're given an opportunity to ask, we can't figure out how our information is being used. And I think those two things are pretty much a minimum of what we need to try to be achieving. So in my view, it's adequate, it's helpful to have the regulation to balance out the economic interests of the data brokers. I think that's fair for preservation of dignity.
Yeah, well, as I said, if data protection becomes an obstacle, we are not doing our job right. I mean, data protection should never be an obstacle, should be a companion. So if there are legitimate needs to collect personal data and process personal data and exchange personal data, and there is a business built around it, that's totally legitimate. But this business has to understand that this has to be regulated. There has to be some red lines. There has to be some transparency, some accountability, some fines. And for the moment that this is in place, the business becomes a safer environment for conducting their own business. Therefore, data protection comes as a way to legitimizing and giving strength to this business rather than weakening it. So this is what we call at the GDPR the risk-based approach. To the extent that there is a risk, stakeholders are supposed to address it and to give an appropriate response. And as Jolynn just said, technology can be very handy to help with this, mitigating this risk, anonymizing a lot of data, putting some firewalls and some need-to-know principles. So whoever tells you that technology, I mean, that many companies would say, but that cannot be done, that's very complicated, that's very costly. Well, when it is for making money, nothing is complicated. But it's for protecting the privacy of individuals, then everything becomes. So I think we have to be smart and tell these industries that there's absolutely no problem, that we are there we understand that they have a business model, and but please, they should take into account very basic principles, which are embedded in many other risk-based activities. They are not new. Huh? They are, every time there is a risk-based activity, there are always some principles, and they just need to apply them with the same rigor.
You just put your finger on really the key question. And, you know, from a U.S. perspective, I think we have to stipulate, well, first of all, we do need more regulation of the data broker industry. It's something that we've been grappling with for years. The Federal Trade Commission's been very active on it, and there's been a lot of, it's part of the discussion in D.C. But let's just stipulate that the U.S. economy, when we talk about privacy and data protection, what we're really talking about is processing of information. And the processing of information is just what's central to the U.S. economy. That's what's really gotten the attention of the White House, the National Economic Council, and the thinking about, and this is where it's going to be, we're going to learn from Europe, but it's going to be different from Europe. But it's trying to find that balance for where we allow for the processing of data, because it's so much a part of American innovation and economic growth, but find, a different level of user control. And it's not an easy balance to find. The data broker industry and the advertising model, it's been essentially unregulated, and so that's always difficult to sort of take a wide swath of industry that's been unregulated and sort of bring them in. The other challenge that you mentioned is notice and choice, and I think that's the other, we enforce against notice and choice, and the consent or notice and choice model has not worked. I mean, it's where we started 20 years ago because that's all we had. But where we are today, I mean, people, like Jolynn said, people don't know what's being collected. They don't have any control. And so we're at this inflection point where, as I said earlier, it's become a strategic issue, but we have to design for privacy and processing and data protection going forward, as opposed to solving yesterday's problems. But it's tough.
Yeah, I would just add quickly to that to me, this issue around individual control breaks down to 3 different subcategories. Situations where it's absolutely necessary for the individual to be able to have some control over particularly negative impacts that might happen to them because of data that relates to them. Then second would be situations where it's inappropriate for the individual to have choice and control over those impacts. Think of things like fraud detection, for example, or anything that in the category like past criminal records, for example, anything in this right to be forgotten conversation that we've been having now for a while globally, where people say that's inappropriate to provide absolute control. But then increasingly there's a third category where it's either impractical or impossible for the individual to exercise control, particularly when the data doesn't come directly from them. It comes from somewhere else. So it becomes, if that's the problem statement, that becomes a unique drafting problem. What do you do in that situation? To me, then what I think you want to optimize is you want to encourage entities to provide choice and control and an opportunity for consent whenever they possibly can, and for them to get benefits from doing so, and then, but provide ways for being able to do the innovative and ethical use of data for those situations where it's impractical or impossible. But they may have to comply with other obligations that go alongside that. So that's what we've tried to draft in Intel's recommended bill. But it's very challenging, and there's a lot of different opinions on this. I think this is going to be, along with preemption here in the United States, I think they're the 2 big issues that we're going to be really debating for the next year or 2. Question right there.
I have a question for Mr. Navas. It's about the recent mega breach of Marriott last year in November. I was wondering that this is like the first incident after the implementation of GDPR. I was wondering your opinion on the Marriott breach because it's currently in investigation. What kind of expectations do you have, or any predictions of the outcome of whether GDPR would apply to the Marriott breach?
I'm not familiar with this breach. Could you please?
Large breach of Marriott hotel chain.
Okay, yes.
So there was a breach in 2016
Yeah.
of its one of its subordinate Starwood Hotel, and basically Marriott acquired the branch, and there was a hacker that potentially breached more than like millions of people's personal data. So right now the status is GDPR might apply to it, so 4% of its annual revenue might be the fines, or
Yeah. Well, GDPR doesn't apply retrospectively, you say that? Retroactively, sorry, retroactively. So GDPR only came into force on the 25th of May 2018. So if the data breach happened back in 2016, the GDPR was not in force, will not apply. But the directive would apply eventually if that was the case. The issue of data breaches has been there for a long, long time. Actually, I think in the US, some versions of data breaches were implemented even earlier than in Europe, and it's a good thing not because us regulators, data protection authorities, we are just waiting there for a data breach notification to come to us, so we can jump and impose sanctions. This is not our approach at all, but because we can use this as a learning tool for the company. So that's why we always encourage companies, if you ever have a breach, please don't hide it, don't keep it for yourself. Be brave and notify this to us, because in many cases, these things are accidents and cannot be avoided. And we are humans, some people make mistakes, so this is not the issue. But once you have this kind of incidents, companies can learn a lot and improve a lot in the managing of their own databases. And therefore, I'm pretty sure now in this hotel chain, after this big breach they will have now probably hired a proper data protection officer, a team probably, and they will have been investing a lot of money in making sure that this won't happen again. So, and other hotel chains will probably also understand that this is a big issue. Therefore, this is all what data protection is all about. It's not about punitive sanctions or about, it's just to have good management, good data management in place. In the same way that companies have management for their own assets, they should have also good management for the data of their clients, because otherwise these clients are exposed to massive risks, and this is not fair. This is simply unfair with the consumer. And therefore, that's why there is a growing awareness in society that this has to change. That it is not sustainable anymore to have a model where data is just there in the cloud. Nobody is accountable for it. And then you ask a question, where did you get this data from? And they cannot even answer. Say, well, this data is in our database, but we don't. This is not sustainable. It has to stop, and we have to find a way where things are managed better. I must say that what David Hoffman just said about the three categories of situations is simply brilliant. This is the added value that the US approach can bring to the equation. This is something that in the European model would have not come to the table so easily. But from the pragmatic approach that you have here in America, this kind of analysis are great. And actually, this is the way forward to identify these categories and to implement it in a business-friendly way, so it doesn't hurt anybody and doesn't hurt innovation.
Well, thanks. We hope Congress thinks as highly of it as you do. Leo, we're going to do one last question back straight in front of me with a quick response.
Maybe we can have everyone ask the questions. Can we get, because I saw three.
Yeah, why don't we do the
three questions.
Three hands questions, and then we'll try to merge them together and give lightning round responses. Straight in front.
Thank you for being here, guys. I wanted to hear your thoughts on urban planning collaborations, such as Sidewalk Toronto, which is a collaboration between the city of Toronto and Google's parent company Alphabet to develop a smart city on prime real estate in Toronto.
Second question.
Yeah, I wanted to get a sense of what the role going forward is for private companies to push governments to enforce more comprehensive privacy reform.
Sure. Third question, all the way in the back. Last row.
You want?
She said last row.
Okay. I think we both had a question, but I'll tag along. At the beginning of the panel, thank you for the great discussion. At the beginning, someone had mentioned the concept of a data bill of rights, and I'm intrigued on what that might look like, what the core principles would be, and how that is similar or dissimilar to the Declaration of Independence of Cyberspace by John Perry Barlow. Thank you.
Fourth question.
Again, thanks for coming here. If the US and EU were to adopt more privacy-focused rules, is that something that could be imposed on places with significantly less concern for privacy? And if not, should we be concerned with the information asymmetry this would cause and the effects it might have on our economies and national security?
That's a good and a big one. So let's go down the line, starting with Dan, and take on what you can take on that.
Yeah. I don't know how to. I mean, the last question is an important one in terms of, at least as I understood your question. I mean, law enforcement and national security in the relation to privacy. So those are very, very thorny problems and in my mind, somewhat separate. So to the question about the Consumer Privacy Bill of Rights, I mean, David could probably speak more to that because of the legislation that he's worked on. But in your question about smart cities, having done a lot of work in the Internet of Things and a lot of thinking about smart cities, we need to be very careful because obviously there's a lot of benefits to information, but cities, as they collect more and more information, to me, they just become a target and kind of a repository. And so there's been some examples, like Seattle's a good example, some things have gone really well and some other things have been more sort of teachable moments. So what I'd like to see with smart cities is more collaboration and sort of learning from some of the opportunities and challenges, because right now it seems like things are just happening in kind of a one-off state, and I think that's something that needs to change.
Okay, I don't even want a smart home. I definitely don't want to live in a smart city. But I think it's a very good question, and it raises lots of interesting issues. The Data Bill of Rights, are you a student here at Duke? A scholar. So if we can chat, I can give you a couple of sites for that. There was a Bill of Rights that got started in the Obama administration and got squelched because of historical reasons and things that came up. This is a new one. The one I was citing to you is in an article by the MIT Technology Review. And it's interesting to contemplate aside from legislation. I was really interested in this question, and I have my student here. So for the people that because we can't answer it all because it's over, but if you write those questions down, and anybody who's in my class, we can have a forum that is on our actual class where we can trade some ideas about those pending questions, because they're really excellent, and thank you for submitting them.
And I would just say, and maybe we have this as a future session with students, I definitely want to live in a smart city, so we will
We'll have a
potentially
smart city.
have a
We'll have a smart city
debate
panel.
on this. But I want to live in a properly regulated with privacy protections smart city. I think a lot of the cities that you're in Europe are turning into smart cities because they have models that allow for the exchange of data between the municipal organizations and the private sector, and there's a governance model there. We could put the same thing in place, and frankly, if we don't, we're not going to be competitive globally in this country. There's too much benefit that we can get from that innovative use of data. One of the things we're most going to care about, and we need to care about when we have those intersections between the private sector and government and those exchanges of data, what are the national security implications of that? Where is the data going? How much do we have to worry about the exchange internationally in that environment? Those are going to be great topics for
our next panel.
Future panels or future data privacy days, actually.
Smart City
Leo,
panel.
you'll come back next year, right?
I will.
That's great. I want to thank the panel and thank all of you for coming here. I have some gifts here that I will get to you guys. Thank you so much, and thank you all for coming.
Thank you very much.
Is the room closing?
I don't think so, because there's no